Welcome to the weekly legal news of FDVN Law Firm. In today's program, we will review the regulations on the conditions for being allowed to change the birth name and the procedures for changing the birth name according to the current law. Nowadays, there are many cases where individuals want to change their names on the birth certificate. For example, in a family, there are 2 or 3 people with the same name, affecting the reverence of descendants for grandparents. The name causes a lot of confusion or affects the honor of that person. Changing names in the birth certificate is a citizen's right recognized by law. However, people are not always allowed to change their family names and given names. And not everyone knows the procedure to change their names. In order to change the name on the birth certificate, what conditions must be met and what are the required documents and procedures? Continue watching to have a better understanding about the regulations on these procedures. We'll start with the conditions to change the name in the birth certificate. First, regarding the conditions for changing family names, Article 27 of the Civil Code 2015 clearly stipulates 8 cases where an individual has the right to request a competent state agency to recognize the change of his or her family name. Including: Number 1. Changing the family name of a natural child from biological fathers to biological mothers, or vice versa. Number 2. Changing the family name of an adopted child from biological fathers or mothers to adoptive fathers or mothers at the request of the adoptive parents. Number 3. If a person ceases to be an adopted child and such person or his or her biological father or mother request to reclaim the family name which is given by the biological father or mother. Number 4. Changing the family name of a person whose biological parents have been identified upon the request on that father or mother or such person. Number 5. Changing the family name of a lost person who has discovered the origin of his or her bloodline. Number 6. Changing the family name of a person to his or her spouses in the marriage and family relations involving foreign elements in accordance with the law of the country in which the foreign spouse is a citizen, or retrieves his or her family name before the change. Number 7. Changing the family names of children upon the change of family names of their fathers or mothers. And number 8. Other cases prescribed in by law on civil status affairs. Second, regarding the conditions for changing given names. Pursuant to Article 28 of the Civil Code 2015, there are 7 cases where an individual has the right to request a competent state agency to recognize the change of their given names as follows. Number 1. Where it is so requested by the person who has a given name which causes confusion, or has an adverse effect on his or her feelings, or on his or her honor, legitimate rights and interests. Number 2. Where the adoptive father or mother of the person wishes to change the given name of their adopted child. Or if a person ceases to be an adopted child and such person or his or her biological father or mother request to reclaim the given name, which is given by the biological father or mother. Number 3. Changing the given name of a person whose biological parents have been identified upon the request of that father or mother or such person. Number 4. Changing the given name of a lost person who has discovered the origin of his or her bloodline. Number 5. Change the given name of a person to his or her spouses in the marriage and family relations involving foreign elements in accordance with the law of the country in which the foreign spouse is a citizen or retrieves his or her family name before the change. Number 6. Changing the given name of a person whose gender identity is redetermined or a transgender person. And number 7. Other cases prescribed by law on civil status affairs. In addition, according to Clause 1, Article 7 of Decree No. 123/2015/NDCP, the change of family name, middle name, and given name for a person under 18 years of age must have the consent of that person's parents and must be clearly stated in the declaration. For persons aged full 9 years or older, the consent of that person is also required. As such, you have the right to change your family name, middle name, and given name on your birth certificate when you meet the conditions specified in Articles 27 and 28 of the Civil Code 2015. When changing family name, middle name, or given name of a child under 18 years old or a person aged full 9 years or older, the consent of their parents is required. Next, the competent authorities to change family name and given name. According to Article 27 of the Civil Status Law 2014, commune-level people's committees of previous places of civil status registration, or places of residence of individuals, are competent to settle civil status change and correction for persons under 14 full years. And according to Clause 3, Article 46 of the 2014 Law on Civil Status, district-level people's committees of previous places of civil status registration, or places of residence of individuals, are competent to settle civil status change and correction for Vietnamese citizens of full 14 years or older, residing in the country, and ethnicity redetermination. Lastly, the procedures for changing name on the birth certificate. This procedure contains 3 steps as follows. Step 1. Prepare the required documents, including the Civil Status Correction Declaration according to the prescribed form, in Circular, No. 04/2020/TTBTP. Original copy of birth certificate. Relevant documents as a basis for changing the family name and given name. And a copy of the identity card or citizen identity card of the person applying for civil status registration, to identify that person, together with the originals for comparison, or a certified copy of the identity card or citizen identity card of the person going for civil status registration. Step 2. Submit the application. Individuals wishing to change their names in the birth certificates shall submit the prepared documents at the commune-level People's Committee, ward, town, or district People's Committee where the person's birth has been registered. Step 3. Receiving the result. Within 3 working days after receiving complete papers, if seeing that the civil status change or correction is proper and compliant with civil and relevant laws, the Justice and Civil Status Officer shall record such change or correction in the Civil Status Book, and together with the registration requester sign in the Civil Status Book, and report to the chairperson of the Commune-Level People's Committee to issue an extract to the requester. After that, write the content of civil status change or correction on the birth certificate. In case verification is required, the time limit may be extended for no more than 03 working days. In case of registering civil status change or correction not at previous places of civil status registration, commune-level People's Committees shall issue written notices together with civil status extract copies to People's Committees of previous places of civil status registration for recording in the Civil Status Book. The change of family name or given name does not change or terminate the civil rights and obligations established with the old name. After changing the family name and given name on the birth certificate, the person who made these changes can adjust the information on the relevant papers in accordance with the law. Above are the regulations on the conditions for changing the birth name and the applications for this procedures according to the current law. We hope this information will be useful to you. Please follow FDVN channel to see more interesting legal information. Goodbye and see you in the next videos.